Myanmar argues that the court lacks jurisdiction, or alternatively that the application is inadmissible because there was no dispute between the parties on the date of the filing of the application instituting proceedings. The court begins by recalling that the existence of a dispute between the parties is a requirement for the court's jurisdiction under Article 9 of the Genocide Convention. According to the established case law of the court, a dispute is a disagreement on a point of law or fact, a conflict of legal views or interests between parties. In order for a dispute to exist, it must be shown that the claim of one party is positively opposed by the other. The two sides must hold clearly opposite views concerning the question of performance or non-performance of certain international obligations. The court's determination of the existence of a dispute is a matter of substance and not a question of form or procedure. In principle, the date for determining the existence of a dispute is the date on which the application is submitted to the court. However, conduct of the parties subsequent to the application may be relevant for various purposes, in particular to confirm the existence of a dispute. The court has also previously held that in making such a determination, it takes into account, in particular, any statements or documents exchanged between the parties, as well as any exchanges made in multilateral settings. In so doing, it to the author of the statement or document, their intended or actual addressee or document, and their content. In this regard, the court notes that in the present case, there are 4 relevant statements made by representatives of the parties before the United Nations General Assembly in September 2018 and September 2019. During the 2018 and 2019 general debates of the Assembly, which took place in the weeks following the publication of 2 reports by the fact-finding mission on Myanmar established by the Human Rights Council of the United Nations on 12 September 2018 and on 8 August 2019, respectively. Also relevant to the determination of the existence of the dispute is the note verbal that the Gambia sent to the Permanent Mission of Myanmar to the United Nations on in its first report. The fact-finding mission stated, I quote, vital intent to be established in other contexts, end of quote. On that basis, the fact-finding commission concluded that there was sufficient information, I quote, to warrant the investigation and prosecution of senior officials of the Tatmadaw chain of command so that a competent court can determine their liability for genocide in relation to the situation in Rakhine State, end of quote, and call nations protect its people from genocide. The fact-finding mission reiterated the statements in the detailed findings version of the same report published on 7 their intended or actual addressee and their content. In this regard, the court notes that in the present case, there are 4 relevant statements made by representatives of the parties before the United Nations General Assembly in September 2018 and September